And we're back with the Certifiably LaCrate Show, where we discuss the behind-the-scenes information young artists and creatives need to know on how to navigate their career as a DJ, music producer, fashion designer, songwriter, whatever it may be. Today we're talking with my friend, and in my humble opinion, one of the greatest arts and entertainment lawyers in the world, protecting artists' intellectual property, their copyrights, their trademarks, and more. So Scott, let's jump right in. What is a copyright? What is a trademark? So many people get them confused. So many people mix them up. Break it down for the young creatives, please.
Absolutely. And first, thank you for having me, Aaron. It's a pleasure to chat with you about this.
This is an honor. Cut that in. This is an honor.
Yeah, I mean, these subjects are important, and unfortunately, artists are not aware of some of these things, and they're so important to artists as their career grows and as their work becomes more popular. Having some legal understanding is really integral to being successful. And so, when we speak with artists, the two types of intellectual property that we deal with most are copyrights and trademarks. And sometimes people conflate or confuse the two, but they're very different, okay? A copyright is just like the word says, it's the right to copy. If you're an artist and you create something, only you have the right to copy that work. And there's no technical or formal requirements that's required in order for you to be able to protect it. You simply fix it in a tangible medium, you create it, either physically or digitally, electronically, and once it's fixed, you have a copyright. Now you should register that with the Copyright Office, and maybe we'll talk a little bit about the registration process and why that's a powerful tool for artists. But even without the registration, you own your copyright. A trademark is more to protect the consumer. If you go to a shop and you see a Nike hat on the shelf, as a consumer, you need to know that that's actually coming from Nike and not from me making a hat in my garage and using the Nike name or swoosh on it. And so trademarks really protect the consumer, and they also protect the brands. So as the brands build up this goodwill with the consumer, another brand can't come along and try to free ride off of that and build their company off the back of the other brand's goodwill. So those are copyrights and trademarks. Okay, so me personally, at a very young age, was very worried about people stealing my stuff. When I came up with the LaCrate logo, I was paranoid. It was the top of mind. Someone is going to steal this. I don't know why. I come from a, dog eat dog, graffiti, hip hop, people will ruthlessly take whatever they want. And that happens all the time. Survival of the fittest. So I was desperate to copyright the LaCrate logo. And trademark it and copyright
well, I started with copyright because I had been told, and I don't know how young I was a kid, that you could do the poor man's copyright. And many people speak to me, well, I mailed it to myself. That counts.
That's absolutely no good. The poor man's copyright, putting it in an envelope and mailing it to yourself with the postal stamp, you may be able to use that later as evidence of when you had created the work, but it really does nothing in terms of registration.
I think I still have my unopened poor man copyrights that maybe I'll, unearth on this as an edit. But so you want what you want to do, and what I find so fascinating, and I think it's incredibly overlooked with both copyright and trademark for any artist, and oftentimes they find this to be just too much work or too much not fun stuff, right? Everyone wants to be a creative so they don't have to do the business side, right? And oftentimes it's very hard to find real advice, and it's too late. Once you didn't find the right advice. So filing a copyright is relatively simple, right?
Yeah, filing a registration, right? Because people use the phrase, I copyrighted the work, but that is kind of a misnomer because you have the copyright just by creating it. What I think people mean to say is that they registered the work. And that's when you go to the Copyright Office website, and there's a portal there. It's not the easiest to use, but it's not overly complex. You pay a fee somewhere between $35 and $55, and you input some basic data about the work, when you created it, when you first published it, if you've already brought it to the market. And you submit it with a copy of the work, and then you get a certificate. The certificate has all that information, your date of registration. And if you have that certificate and someone infringes your rights, they use it without your consent, then you have a strong piece of leverage to enforce your rights.
What is the difference between an artist who created it? Let's say he wrote a song, he produced the music, he owns it solely. Someone steals the lyrics, or they sample his beat, or whatever they end up taking, and he's it calls you and he says, this is a clear infringement, and you're like, it kind of is. Do you have a registration or a certificate? And he says, no, I don't, but I made it. What's the difference?
Yeah, so there's two really important things that arise if the person calling does not have the registration. The first is we have to take a much closer look at damages, because one of the real powerful pieces of leverage that you get with the certificate is no matter what the infringer profited from using your work, even if the infringer only made a modest profit from it, you can seek statutory damages of up to $150,000. You cannot seek those statutory damages unless you have a registration that predates the infringement. So that's one of the elements. The second, oftentimes the more important, is the ability to recover your attorney's fees. Both copyright and trademark cases are in federal court. And in federal court, litigation is very expensive. And it's not uncommon for a copyright case to cost more in attorney's fees than the case is worth. So even if you're the best attorney in the world and you go to court and you recover all of the profits that the infringer made from infringing your copyright, that amount may be less than your attorney's fees. And you're stuck in this position where you win the case, but from a business perspective, it's not great because you've spent more on attorney's fees than you've recovered in the case. With that timely registration, you can recover your attorney's fees from the infringer. So you're able to recover your damages, plus have them pay your attorney's fees. Now, it's in the discretion of the court, and there's factors that they look at, but it provides a very powerful piece of leverage at the outset of the case when your attorney is talking to the attorney for the infringer in connection with trying to get the case settled, because that attorney will tell the infringer, look, you may be on the hook not only for the damages, for the defense attorney's fees, and also potentially the plaintiff's attorney's fees.
Gotcha. And to get to that 150 statutory maximum damages, how difficult is that? Is there a threshold? Is there a criteria of getting there?
There's a number of factors that the court's going to look at, including the level of success in the case, the positions that the parties took during the case, whether or not they were reasonable or not. And there's also this issue of willfulness. The more willful the infringer, the more likely it is that they're going to pay the attorney's fees for the infringement.
And let's talk about willfulness really quick. What constitutes willfulness?
Yeah, well, willfulness is when the infringer knew or reasonably should have known, right? They can't bury their heads in the sand. So it's whether they knew or reasonably should have known that what they were doing violated the rights of the artist. And it can be difficult in cases in the fashion industry, for example, because you may see a large retail chain selling a garment that has an artwork that's 100% your art, right? Exactly like your art. And you'd say, oh, come on, this has to be a willful case. But then you get into it and the retailer says, well, actually, we bought it from this wholesaler who bought it from this other company, and that was the company that was the willful party. We were just duped and bought this infringing product. And so it can get complicated, but assuming that your attorney does their due diligence and brings into the case everyone that's responsible, you should be able to identify the real bad actor. And again, it doesn't necessarily matter for the profits, because the law is very clear. No one, even an innocent infringer, should be able to profit from selling an infringing good. So even the retailer in that example that unknowingly bought this dupe or this counterfeit or this infringing item, they still have to disgorge their profits. But it's the bad actor that will generally be the one on the hook for attorney's fees.
Gotcha. I think back to the value of a copyright. I mean, as an investment in your career, in your art, for $35 to $50. I mean, I don't know what else you can do in your career where you can actually, kind of protect and reserve your rights in the event of a problem than filing a copyright, which is great. I have Milk Crate logo copyright and I have Milk Crate logo trademark, right? Both.
Double protection.
Double protection.
And you can seek damages, different damages for each of those.
It's just a benefit people don't realize. Trademarks you have to renew constantly, so you really have to kind of be on top of dates and admin and things like that. But a copyright for $35, you have it for what is it, for 100 years after your death?
At least your lifetime, yeah, plus decades afterward. And it does a couple of other things too. It provides a rebuttable presumption that you own the artwork. And the rebuttable presumption says, look, the Copyright Office issued a certificate saying, I created it, I owned it. It's now up to the defense to come and challenge that. That's very powerful, that ordering the evidence that way. And it also allows you to go into the litigation or the pre-litigation conversation and say, look, these are the facts. This is when I created it, I registered it before you used it, so clearly I was in the marketplace with it before you were. And that gives you an upper hand when you're dealing with these infringers.
And that's on copyright side?
That's on the copyright side.
Gotcha. And now on the trademark side, explain that a little bit. Obviously, copyright can be music and design related, and also literary, right? Like that's what it covers?
It covers all of the creative works. If you create music, a fashion design, if you write a book, if you create a film, all of those are going to be covered by copyright, and you're going to have what we call your Section 106 rights, right? Which are the artist's exclusive rights to reproduce it, to display it, perform it, distribute it, all of those things. And if someone does that without your consent, that is when you have this legal claim.
I think I copyrighted an idea for a TV show. It was called Homeless Got Talent. I have to check. But let's say I did.
Well, here's the thing. Ideas are not copyrightable, right? So one of the judges once eloquently wrote, ideas are as free as the air. Anyone can use the idea. What you get protection for is your expression of an idea. So we have this idea-expression dichotomy. And so in your treatment or whatever you wrote up, I'm sure you included some expressive elements, how you expressed the idea for that particular game show. Now that would be protected, but the general idea, the concept, would not be.
I could probably get hit with Got Talent, right? Because that's probably trademarked.
Well, you'd have to look into that and see whether or not the consumer would be confused.
They're going to get. So that's why you're going to get hit one way or the other. So, but trademark is specifically more so use in commerce.
Yes, that's to protect your brand, right? And so if you are developing a brand, one of the first things you should do is register your trademark. That gives you a presumption and rights that you can enforce against folks that come along after you and adopt a mark that's confusingly similar. On the copyright side, when you're comparing artwork, we use what we call a substantial similarity analysis. Would a person looking at the two works consider them to be extrinsically and intrinsically similar, or would two people viewing the works consider one to have been copied from the other looking at them? Trademark, we look at a confusion standard, right? So if you're a consumer in the marketplace, at the shop looking at this product, would you be confused as to where that product originated from? The hat, it has a symbol on it that looks kind of like a swoosh. Do I think that maybe came from Nike? Is there that association there? That confusion is what you look at in a trademark case.
Confusingly similar, right? But it also has to be used in a non-decorative brand. What is it called? It's called a source identifier way.
Yeah, this is important to, particularly in streetwear where folks come to us all the time and say, look, I have a trademark for this design, and we should maybe back up and tease out the two types of trademarks, right? You have your word mark, and then you have your design mark. The word mark is the name of the company, Scott's Shoes. The design mark is the actual artwork, the logo. But folks come to us and say, look, I have a design mark for this logo. This company, this very large retailer, let's say, is selling t-shirts that bear my artwork. Can I bring a claim against them? We say, well, you probably have a strong copyright claim if the work's creative enough to be protected. But the trademark claim, we have to look a little more closely at it to see if it's an ornamental use or an embellishment. And again, this is going to come down to the consumer mindset. The consumer looking at it, are they going to think, oh, this particular shirt originated from the source of that logo, or are they going to think that it's from somebody else and this is just a decorative element?
And nowadays, in the collaboration mania we live in, or are they going to think it's I forget what it's called, something enriched collaborative of the two brands, right? Even if you're a little brand, there's an argument to be made that a larger brand, some people would say, there's no likelihood of confusion between X and Y, X being a tiny streetwear brand and Y being a humongous, famous athletic brand. But in today's marketplace, could be because collaborations happen all the time.
All the time, yeah. We call that reverse confusion, right? That's when the second company that comes along isn't trying to use the first company's mark to trade off their goodwill. They're just adopting the mark because they like it, and then their use of it sort of steamrolls the smaller brand, where folks think that the smaller brand's products are associated with the larger brand. So you have your forward confusion and you have your reverse confusion based on the companies and the marks that are at issue.
And what is the exact argument for reverse confusion again, though? So it's like the argument is that the larger brand falsely enriched themselves off of the benefit of the cooler, hipper, edgier thing that they're not.
they could be free riding off the goodwill or the credibility of the other brand. But there's also this issue of the smaller brand's business being damaged because folks think now that this mark that they used first in the marketplace is associated with this other company and not theirs.
And also, it's a third concern is that now it's no longer good enough to just get the small brand, because the confusing of, oh, the small brand plus the big brand equals a fusion of more. And the small brand on its own is no longer worth as much without the big brand. So how do you proceed in the marketplace when people say, oh, gee, they might have thought you got a big break as a small brand. Some people may think this is a legitimate collaboration, but ultimately you were ripped off. And then moving forward, people think that when people realize that you didn't indeed get the props, right, or the cred of the cosign,
right,
which is so big,
so important.
I mean, I just saw someone do an Instagram post recently that collaborations have killed streetwear. It's like, no, that was about in 2015 or maybe 2010. Right. Like it killed it a lot.
All those X deals, brand X brands.
A long time ago that happened, and now it's like if it's not two things, it's not worth enough, right? So how does the little brand look when everyone realizes that they didn't get the cosign? Right? So, shit, we were happy for you for a second, but now we realize you were just a victim.
Right. And it's very difficult with advertising budgets because the bigger brand can flood the zone with marketing and
PR
stories.
spins or whatever, narratives. And then what happens is that as a little brand, you let's say you've put 20 years into this idea, it's your life's work. And this is how you feed your family, whatever it may be. Maybe it's a small family brand, boyfriend, girlfriend, whatever, or a lot of these brands were boyfriend, girlfriend, baby. Small families, and they're starting to have success. And here comes some issue, some infringement, whether it's copyright or trademark, and people are excited, then they're disappointed, then they enforce their rights.
Yeah.
And now there's a public outcry. How dare you, little brand, sue big brand? Who do you think you are? Do you think big brand would ever really collaborate with you? Instead of, it's like a reverse David and Goliath story. It's like little brands just trying to,
Right. Well, we see that both ways online. A lot of the times we'll see folks coming out in support of the smaller brand or the artist because it is the extent, it's the public town square now on social media. Folks are supportive of artists, and when they see these brands ripping them off, or even if it's a smaller independent brand, that has maybe a more modest following, but a very fierce and passionate following, and this other larger corporate, behemoth brand rips them off. I've seen a lot of folks coming out and supporting them, but you're right. Sometimes they come out and say, hey, I'm a big fan of this great brand, and they're this wonderful thing. Why would they need to steal from you, right? They're this huge thing. But I think that goes to your point earlier, which is like the credibility of it all is so important. And it's one thing these large corporate brands don't have is that credibility. Yeah. And they can kind of vampirically take that from the streetwear brand, and it's extremely damaging.
Yeah, it's fascinating, the power of brand, and you really when you get into that battle, you get to see the power of brand psychologically that it has on consumers or fans or followers, and how the power of brand and being able to protect your brand via copyrights and trademarks is super important. Should be the first thing you're on top of as a young creative. So basically $30 to $50 to copyright. Trademark might be about $300-400 nowadays.
That's good. And if you can do it yourself and you feel confident, you should absolutely do it.
I did my trademarks 1997 pre-internet on a typewriter.
Okay, wow, you typed out all the information.
Typewriter and mailed them in.
Old school. Okay.
That's what existed.
Right. Yeah, now there's an online platform, and so it is a little bit more.
It was kind of easier pre-online platform. Online platform is like a little. I have some things I need to copyright right now. Trademark online platform I find much easier. Copyright online platform a bit more confusing.
There's some things in there, for example, like the definition of publishing. It's not the normal definition of that we would think of publishing. It's when you first offer it for sale or license to the public. And that sometimes throws people off.
I'm glad you went there, because now let me speak to my music producers. as me being a guy who makes beats, has made beats, used to circulate CDs, used to email tracks, does that constitute publishing?
Yeah, if you're sending that email with an offer for them to license it from you, then yes, 'cause it's an offer to license. It can get confusing, particularly with online work, for example, like photography, let's say. If you put a work up on your personal website or your Instagram account, you're not necessarily publishing it because you're not offering it for sale or license. But if you had a caption that says, "Contact me to license this work," then you've arguably published it because you've offered it for license. So it can get a little bit complicated with online displays, but that is something that folks should check with a lawyer about. Because we actually had a case over the definition of publishing that went all the way to the Supreme Court, and we took years and years to get to the bottom of it. Luckily, we won at the end, but it just goes to show that these issues are so complex, even judges along the way had some issues with applying that definition.
What did they end up defining publishing as again?
Well, in our case, it was a situation where the act of publishing, there's a section on the registration where you indicate whether or not it was published. We had indicated incorrectly, arguably, that it had not been published when it was, or vice versa. And the Copyright Office said, well, it should have been this way, and you entered some different information. When it went up through the courts eventually applied the statute and said, an error like this should not allow an infringer to get off the hook. And this is a case that we'd taken all the way to trial. We had won, and the infringer basically just exploited a loophole to evade liability. But the court said, the Copyright Act is there to encourage artists to create art and to enforce their rights. And so applying it in this way is just not what we should be doing. And so now we have a little bit more of a window into what we should do when we register works as published or unpublished. But again, everything's constantly evolving, and with new technology, the Copyright Office forms are always a little bit behind. And so we have to constantly keep an eye on what the definition is going to be for each of the sections in the registration.
I've had some instances where I've had opposing counsel arguing the validity of a copyright of mine. It seemed like it was a pretty high standard to invalidate a registration, even a wrong checked box.
Yeah, and that's what there's a section 411 of the Copyright Act that says that says, look, it's already hard enough for artists to make art and make a living, trying to monetize their art. And for those that come to the Copyright Office and register, as we want them to do, we shouldn't make it a terrifying experience for them where they're hovering over this box, whether or not to check it as published or unpublished, or a work for hire versus this other type of work. So as long as they do their best and they're not trying to defraud the Copyright Office or knowingly putting something in there, right? Like, oh, they're trying to register Mickey Mouse when they don't own Mickey Mouse. Right? As long as it's not something that's material, that goes the actual copyrightability of the work, an error is not going to invalidate the registration.
I'm glad you brought up Mickey Mouse, because let's talk quickly about public domain and the opportunity to use, is it 100-year-old artwork, music?
You can certainly, once work falls into the public domain, where I think now the first Mickey has fallen into the public domain, you can use that work. Now, you can't claim a copyright on it, right? That's one of those things. If you were to go to the Copyright Office and take something in the public domain and try to register it and say it's your original work, can't do that. They probably should invalidate your registration for doing that, because you can only copyright what you created. But can you take something in the public domain and incorporate it into your work and register it? Absolutely. There's actually a section on the registration, and it's great we're talking so much about the copyright registration, but a section on the registration where you limit your copyright, right? And so you say, look, I may not have created this Mickey Mouse that's in here, but I created everything around it. And so I'm not claiming copyright in that Mickey. I'm claiming copyright in my work around it, and then the work in total.
So I can do a 1930s Mickey DJing with milk crates around him, and I can file a copyright and say, I didn't create Mickey, but the rest of the design is mine.
I'd have to do the math to see if that Mickey's in the public domain already, because that's an interesting angle that, Disney, of course, great lawyers, very smart people, they've iterated on Mickey over the years. And so that original Mickey may be in the public domain, but the 1930s Mickey or the 40s Mickey or the 60s Mickey, to the extent it does look different, may not be in the
Well, what are we, 100 years is what? I'm not mathematical right now. What's 100 years? What year? What does that put us at? Right now. We're at 2025, so 1925 art is public domain?
So there's two different terms, right? One for an individual author, one for a corporate author. And so I believe a corporate author, it was extended through a congressional amendment.
Oh yeah, corporations
Sonny
extending
Bono,
their production.
Yeah, it did. And so
and incorporate. We'll talk about that in a second.
we'll definitely talk about incorporation and why that's important. But yeah, so that the public domain material is available then for anyone to use, because the folks have at that point monetized it, made their money from doing it,
right?
And so now others
they've had their opportunity, but corporate is longer. So I'm sorry, what's corporate again?
It depends on how long people.
How would you know that?
I'd have to look at the exact numbers. It's either like the life of the artist for an individual plus 90 years, and the corporation is more than that. We'd have to double check that on the actual numbers, but it's quite a long time.
So it'd have to be an artist that was not incorporated. Is the specificity of that like?
Well, here's an interesting thing that also comes up in the registration and other processes. Works can be created either by an individual, by you or me writing something down, creating it, or by a company as a work for hire. Now, when something's created as a work for hire, the company is the author. It's a strange legal fiction. Obviously, a company has no hands and can't create something, but a company can hold a copyright as an author. How? Two ways. The first of which is if an employee, if you're working for a brand and you create artwork for that brand and you're in the capacity as an employee, the company's going to most likely own that as a work for hire. If you sign an agreement with a third party saying, I'm going to create something for you as a work for hire, and it falls into one of these categories that's set forth in Section 101 of the Copyright Act, again, the company will be the author. And there's a really interesting distinction there that we may talk about if we talk about termination rights, which I think is something that all artists should be aware of, particularly artists that were creating back in the 90s. But you really want to keep an eye on if you are working with someone, right? Maybe you're not an employee, maybe the situation is a bit nebulous. You want to make sure that it's explicitly clear whether or not the work's going to be a work for hire or not.
But let's do a quick pro tip. Music producers, you're shopping beats. What's the best way to do it? You're emailing tracks. Some people think, oh, you got to put your producer name on there. Obviously, you have a record of the email. That's technically, what is that called again? If I email a producer a track and he potentially infringes upon it, that's
so they have access. They have access.
That's a big thing, right? Access. But is there any other things that they should be doing? For instance, before you shop any beats, you can register a collection of those beats. 20. Is there a limit on collections?
Up to 10.
A catalog, is it a collection or a catalog?
If they're individual works, you can do up to 10.
10. Mm-hmm. Okay, so 10 tracks.
Or if you're doing it as an album, which you could do, then you can have more, because then you're registering just the album, though there are issues with doing it that way in terms of how statutory damages are awarded that are a little too technical. Maybe we can talk about that in a follow-up. But what you really want to do is a couple of things. First, you want to make clear that it's your work, you created it, you've copyrighted it. That can be done in a number of ways, even incorporating metadata into the audio files. But you also want to make sure that you're sending these with the understanding that they're going to be used in a project with you. You don't want to have a situation where you just email somebody, check out my beats, and they think, oh, wow, these saying I can use these, do whatever I want with them. And then there's a big dispute. You want to be very clear when you send that email as to what the understanding is. And if you're a professional and trying to monetize your work, you want to say, look, I'm sending you these beats with the understanding that you and I have that if you do a song, you use them, you're going to license them from me, or we're going to collaborate, or there's going to be, a further agreement. I'm not sending these to you so you can use them and do whatever you want with them.
Right.
That clarity is important.
Gotcha.
And you should definitely register before you market.
Gotcha. Register before you market. And then let's talk quickly about the two types of copyright registrations, which is a Form SR and a Form PA.
Yeah, for every piece of music, this is something that is also a bit of a nuance. There's two different copyrights in it. There's a copyright in the composition, right? The way the song's written out. And there's a copyright for the sound recording. The actual disc, as we used to have, right now it's oftentimes a digital file. that embodies that composition. And different folks have different ownership rights for the composition versus the sound recording. If you register the work and you own both, generally the best way to do it is you register the sound recording, and also at the same time, you're registering the composition. You can indicate that in the copyright form, so you get both.
So you use a SR and write words and music and underlying music composition on form SR, and you're covered.
And you're covered for both the composition and the sound recording.
Very cool.
And the way that would work in an infringement case is, if the sound recording is infringed, it's almost always a sample of it, right? And you can bring a claim for them copying directly from the sound recording. But that case will also involve, most likely, a copy of the composition, because the composition's embodied in the sound recording.
Right, so you have the actual music, a loop of the actual sample of your actual music as a potential infringement. We could break down infringements. So there's multiple types of infringements, but one particular one is an infringement on the sound recording, which would ultimately be your master, which would be the actual identical looping.
Yeah, not replaying, but actually playing your sound recording in their song.
That would be, well, then you got the interpolation, which would be them
replaying it. That would be the composition.
That would be the composition side. So you have a potential replay, interpolation, which would be incorporated under the musical composition.
Yes.
Or a infringement of the sound recording, which would be an infringement of the sound recording.
Yeah, if you're remixing the sound recording, sampling the sound recording, using actual elements from the sound recording in your work, then yeah, you violated this. You may have violated both the sound recording copyright and the composition copyright. But if you interpolated it, replayed it, then you're almost certainly going to have violated the composition, but not the sound recording.
Now here's a quick quiz for young creatives. Can you trademark a song, Scott?
No, you cannot trademark a song.
Okay. Can you copyright a what? What's a ridiculous thing? Can you copyright a what?
Single piano key?
Yeah, that's good.
You cannot copyright a single piano key. You can't create something unless there's no bright line, but really unless you can see some authorship in it.
Now, that gets tricky too, because so many people have done so many, how do you feel about the argument of, and you can explain it, there's only so many notes. What's that argument?
There's only so many notes, and all the notes by themselves are not protectable, right? And again, it's hard to draw a bright line, but when you start combining those notes with other musical elements, eventually you get to the point where the work's protectable. And the courts have looked at this many, many times, and in one case, I think it was like a single trumpet blast. The court said, that's not protectable. You can't even tell, who created that. It's a single blast, not protectable. But on the other side of that, when you get to 4, 5, 6 elements that have been creatively arranged, you may have protection in that. And really, it's up to the, a jury, an audience. Does an audience listen to this and say, this has value? Or do they say, nah, that's just a trumpet blast. Anybody could have just hit that button.
But a trumpet blast in a particular structured melody, now you're going somewhere else.
Yeah, when I say blast, I just mean like...
You need a hit. Yeah.
But yeah, exactly. As you start playing it, at a certain point, you're going to hit that line where you cross over into a protectable work.
Drum patterns can be protectable?
100%.
With drum pattern with no musical melody?
100%. Okay. You can imagine a guy sitting down at the drums and banging out, a fantastic drum sequence, and of course that's
it's so interesting right now. And my history, Baltimore club. Mm-hmm. There's a very specific drum pattern. We just interviewed DJ Enough. Mm. So Baltimore club's a 30-year-old, 40-year-old genre. I grew up around it. Know the original creators of it. All sampled off of a lot of samples, a lot of unoriginal drum loops that ended up creating the iconic sounds. But there was a particular drum pattern that was most notably known for Baltimore club forever. It's like a big 808 and clap. It's like a boom, 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 which most dance music is boom, boom. So this was like a boom, boom, like multiple booms and a clap. So it was a very distinct of this genre. Then along the lines, Jersey and Jersey club took it. And the fact that Baltimore is such a hard knock city, and Jersey is a bit closer to New York, a bit more metropolitan, a bit more creative. It has a lot more artists came out of Jersey than have come out of Baltimore. They were able to run with this and rebrand it as Jersey Club. And a lot of my early work when I was dropping my Baltimore stuff, which was Baltimore Gutter, we were making sure that we created the sound without samples. But before me, there's a big record, I think it's called Dick Control, that is the originator of that drum pattern, at least that's what people say. But maybe there's something predates it, I don't know. But I wonder if Dick Control, whoever programmed those original drums, is the owner of the sound that now has become, I was positioning this club music, which was dance music, it was ghetto dance music, but as hip hop. I was like, this is no different than hip hop. It was our hip hop growing up. It should be embraced by the New York hip hop community, DJs. So I had a lot of it was trending and I was able to service it to a lot of people. And it made it to a next level. And then I was in the studio with many people trying to get artists to record on this. It was very difficult because once again, this is it's 130 beats per minute. It's a difficult thing for rappers to rap on at that time. And pop singers to sing on for whatever reason at the time, because it wasn't very melodic. These beats were not, there wasn't much melody for a songwriter to really, it was raw drums, but distinct raw drums. But now it is literally in every major hip hop song, from Lil Uzi Vert to Ice Spice to Nicki, I mean, we were up at Hot 97 and they're doing a live mix and every song is boom, boom, is that. And these aren't remixes. These are major streaming, selling hits. Okay, so like my vision has been fulfilled. It got where it was supposed to get. Not as being known as Baltimore Club, being known as Jersey Club, which is a bit disappointing. I mean, I could always still step back in, and my new project's called Back in the Club, so who knows.
Yeah, you can reclaim it.
I'm going to reclaim it. I did it before, I'll do it again, but that's fine. The battle continues. But my question to you is, I wonder if Dick Control producer has a claim to all these new records coming out.
Yeah, I wonder. You should look into whether or not he created it, you know, if it's creative enough to garner protection. Is it closer to that single trumpet hit, or is it closer to a fuller song that warrants protection? It would be interesting.
I got to see who owns Dick Control now. But now let's say there was a hip hop record by Eric B. and Rakim that was slower. It wasn't 130 beats per minute. It was 95, but it was very similar. Boom, 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 versus boom, boom, boom.
Right, BPM slowed down.
Boom. But let's say the drums were, this is 4 808s and a clap, and that was 808 clap, 808 clap. Very similar, but different arrangement of 808 clap. Is an 808 considered a note? Is a clap considered a note?
I mean, assuming that it's protectable, right? That's the perfect example of something where a jury can listen to it and say, did I think they copied this, or is this something that's just independently created, or is it something that's so simple that it shouldn't be protected?
And going back to, big brand versus little brand, often it's big brand, big producer, artist nibbling in the cookie jar of little unknown guy.
It's almost always, big label, really, right? The label's the one who is often driving the defenses in music cases. And they have all the lawyers in the world, independent artists, musicians. Even 20 years ago, when I started practicing copyright, artists did not have huge litigation budget to litigate these things. Nowadays, in 2025, even more difficult, right, to earn a living as an artist. And so very, very difficult in terms of, being able to bring these cases against these labels who have endless budgets, right, and who have done this over and over again. And that it impacts things two ways. One, it's the actual case, getting from the beginning to the end. Expensive, takes a long time. Can the artist make it through? And two, it's in the case law, because we work in a precedential legal system, right? And so when one case gets decided, the judges that look at similar issues later look at that earlier case law. And what has happened, unfortunately, in a lot of arts cases, and to your point, this is often a result of attorneys that may not have the experience or may not even be specialists in copyright that are handling cases like for a friend that's an artist who really has a good case but might not have the litigation budget up against these, well-paid infringer attorneys. The cases have not always come down fairly in the actual precedent. And then in the next case, that the same label attorneys often say, well, look, Your Honor, in the last case, this is what the judges found. You should find something similar here. And so that, that uneven playing field has really been a problem for artists.
Like even we say, people get confused with the definition of copyright and trademark. To expect a jury to understand a drum pattern or musical composition or notes, or a judge, I guess you're kind of like the luck of the day, I guess.
Well, I think you rely, the juries, and we've done more copyright jury trials than just about any other firm over the past 10 to 20 years. But in our experience, the juries have almost always gotten it right. Because juries, better than almost anybody else, they listen to music, they look at art, they live in the world, they understand, how creativity works and how it impacts them. And they can listen to a song or they can look at art and say, well, yeah, that was copied from that. There's no way this person independently created it, right? They've taken from the person. Going back to what I said at the beginning, it's the right to copy. And juries are better positioned than almost anybody to look at the art and say, yeah, that was copied from that.
Gotcha. So young creatives, once again, when you make your music or you design your first logo, spend the $50 and register it. Even if you mess it up, you're probably still better off than not doing it. Now, on the trademark side, some tips there is that when you start selling something, because there's a bit of a criteria there with a trademark, when you come up with your design, you can do what? It's 1B or whatever it is that's called.
In use, use in commerce.
What's before use in commerce?
Intent to use.
Intent to use, which is tricky because now you have to pay to hope to use it, which...
Well, to get a trademark registration, you can register either with an intent to use, meaning I'm working up this company, we're going to go to market in 5 months, I want the registration now because I don't want someone to knock me off, when I go into the marketplace. Or you can use a use in commerce application saying, look, I'm already using this in commerce and I want my registration based on that use.
And now, once again, make sure you hire Scott to do that work for you, because you don't want to mess any of these things up.
You don't want to mess anything up.
The initial investment is worth it, and you'll know it's done right, and you'll have questions, and you'll get answers. And don't use ChatGPT to figure any of this stuff out.
Please don't.
You need this guy. But
one of these who's having a lot of now is folks sending me ChatGPT generated breakdowns of their case, and it's almost always wrong. If anything, it's like it takes longer and it ends up costing more because we have to wade through that. But yeah, it's worth it. Also with contracts, if you're a producer, a musician, any sort of creative, you're making your first deal, I know it's going to be exciting, and you're going to be a little worried about maybe losing the deal, but have an attorney at least look at it. The amount of times when folks come to me with a deal later on and tell me what they think it says, it often doesn't say what they think it says, and so it's really important. Even if they're not going to negotiate it further because you're worried about losing the deal, at least have an attorney read it and make sure that it comports with your understanding of the terms.
Yeah, there's still that one thing I want you to help that get me out of, get me paid on. So definitely make your design, right? Hopefully it's original enough. You want to do a quick search on the trademark, uspto.gov. Know that site, love that site. Make sure it's available. Then come to Scott and let him do the rest. But you want to be using it in commerce. As a young DIY, creative, I suggest make your shirts. Make sure that your logo is used as what they consider a source identifier, which is usually a left chest small print, or a label or a print in the neck, or a hang tag. Not a big logo on the front. Not really considered. It could be just your name, Scott's Athletics, but chances are that's going to get rejected because it's decorative. It's not deemed as a trade
source identifier. Yeah, you want to use it on the packaging, on the tags, on places where, as a consumer, you would expect the brand name to be.
Yeah, I've seen so many people send in a big print and get rejected and not understand why. So that's not something. So look, you could be off to the races. You could have your copyright and your trademark, and now you can run around and exploit your mark. Let's talk quickly about in a particular class, right?
Sure, yeah, you could be doing, if you're doing streetwear, for example, but you want to get into candles, you'd have to go to the back to the trademark office and expand your trademark registration, because trademark registrations are for a particular category of goods. And as you expand your business, and nowadays everyone that comes to us, they want to do a lifestyle brand where they're going to be selling everything, and they want to register in every group. Not usually the best idea, because it gets a little bit more expensive, and unless you're actually using it in that category, you have to file on an intent to use basis, then go back. And so you really want to be strategic about how you register, but you also want to be in touch with your attorney. And as you add product lines and things like that, you'll talk to your attorney about registering in additional categories.
And make sure you use it in commerce, right? And also in interstate commerce particularly, right?
Sure. Nowadays it's kind of a global marketplace, so you want to show that you're using it as broadly, as you're actually using it, and you have evidence of that. And
just having it in your web shop is the standard for that. Let's say you have no sales, but you have your shirt for sale in your web shop.
You can argue that you're offering products bearing the mark in commerce.
Is that usually the standard?
Using it in commerce is what you're doing, and so sales are of course one way to use something in commerce, but advertising is also.
So posting on your social media is another.
That's one way to do it.
Right.
Sure. Having a website. Yeah.
So it's not really about having 1 million followers. It's not really about having a bunch of sales, which I hear a bunch of people tell me, young artists say, well, I haven't sold enough yet to trademark a copyright. That's not true. Oh, I haven't sold enough yet, or I don't have enough followers to do that, or I'm going to wait till I get more followers.
Yeah, generally by the time you do blow up or get that big, that's when people are going to infringe your trademark, and so you want to be ahead of it.
What about being able to go back into finding dead trademarks and just straight up starting a brand out of it? Let's say you find some super cool trademark for clothing that has been abandoned even a year ago. Let's say a year ago.
Yeah, if a mark has been abandoned, there is oftentimes a grace period for it to be revived. But yeah, once a mark's abandoned, and again, it's a little bit different in terms of rights, right? Because a copyright, you create it, you own it for the entire length of the copyright. A trademark, you own it as long as you keep using it. And so if you stop using it, then you essentially abandon the mark. Somebody else could pick that mark up and run with it.
And vice versa. As a brand, you have to, I believe, be able to prove sales within 3 years to have maintained it. So for instance, if you have Scott's Athletics and you don't sell any product, this is a good question, for 3 years, you have no sales. Can I file
cancellation
yes,
proceeding?
Can I file a cancellation proceeding and demand that I want to now have run with Scott's Athletics?
Like all lawyer answers, it depends, right? Selling is not the only way you can use it in commerce. If I'm advertising, maybe I'm just very bad at business, so I've got a bunch of products, I've got a website, but just no one's buying, then I'm arguably still using it in commerce. So you wouldn't be able to do that.
How about pre-website argument?
If folks are selling it in a store but no one's buying it, you're still using it in commerce.
No sales.
And you're not offering to sell it either?
Maybe you've posted a picture of a t-shirt on your blog.
Yeah, then it becomes a bit of a gray area.
It becomes harder. Right?
Are they using the mark or not? And you'd make the argument, look, they're not really using the mark. They just have a blog out there, but it's not actively engaged in commerce.
So using the mark means, at least have it on your web shop available, which is something everyone can do. You can put your shirt in your web shop, with your word mark and your design, your logo design, and at least have that level of protection, because these are things, I don't know, I worried about these things obsessively as a young creative. I don't know why.
It happens infringement happens every day.
Yeah.
Every day, and it's never been easier to infringe, to get access to somebody else's either their copyrights or trademarks, determine whether or not they're popular.
Yeah.
And then
so let's jump into social media. We've kind of covered the basics of how you can protect yourself. Nowadays, you can let's talk Instagram. You can have a creator account or a business account. And so many people I see with creator accounts running a business, promoting a business, utilizing famous music that exists within the Instagram platform to market. You can add whatever song you want. Taylor Swift, you can put her song to your candle commercial. You're holding up your candle and your t-shirt and you're saying, this is my new streetwear candle brand, and Taylor Swift's song is playing in the background. Can you get sued for that?
Absolutely. We're still at this weird inflection point with social media where it's now become the largest marketplace in the world. We'd all, I think, agree that it's the biggest marketplace in the world for folks to market and sell their product. But it's still treated as not like a Wild West environment, but an environment where folks don't have a firm understanding that commercial rules apply there. And so if you're a large brand and you use a song in an Instagram ad, it's no different. It's probably even more impactful than using it in a commercial during, a primetime television show. And so, much like you would clear a song or a photograph or any sort of IP for use in any commercial, there's no reason to do it differently because that commercial is on Instagram. And basically anything that a brand is doing on Instagram is a commercial to promote the brand.
Is that considered a willful infringement?
It should be. Yeah, I mean, the more sophisticated the brand, the better the artist's argument is, look, you should have known better. You shouldn't be taking, my song to advertise your new, trainer or your new shoe without my consent or without credit or without compensation.
I think these are areas that the average, even current content creators don't know. So many people are just ripping and running and thinking that there's that it is the Wild Wild West. If you look, I've read the fine print on CapCut, and I've read the fine print on the songs that they have available in TikTok. And it says specifically not for commercial purposes only. This is for individual use only. Any usage deemed commercial, which is selling anything, right? Or even just being a brand page is a commercial entity.
Yeah,
is copyrighted.
And that language isn't to protect the creators. That's to protect the labels and the folks that have made a deal with the platform saying, look, you can use the music, but it has to be for the folks using it for their personal accounts, not for these brands who have co-opted the platform.
Can everyone get sued at that point? Let's say I have my original beats that are distributed within TikTok and Instagram, and X large brand grabs one of my cool beats and throws it on a thing. And can I sue Instagram, TikTok, and the brand?
You cannot sue the platforms. The platforms have what we call 512 protection, which basically says that anytime you have user-generated content, you think of eBay where folks are selling stuff, you think of Instagram where people are posting stuff. As long as they take it down, the platform takes it down, the platform is actually immune from liability for copyright violations. Your claim is against the party that posted it.
But you technically could sue Instagram. Would it get immediately dismissed based off of that ruling?
It depends. 512 is a complicated statute. But so long as they comply with all of the provisions of the safe harbor, they're likely to be immunized.
And 512 would be probably their first defense, right? They would move for dismissal off of 512 generally.
Yeah, I mean, this is another one of those statutes that I think was well intended a long time ago, but that the lawyers, the tech lawyers, have done a great job expanding. When 512 was first promulgated as part of the Digital Millennium Copyright Act, right? This was back in '98. It was basically meant to protect, your online bulletin boards. If you were really into Star Wars and you ran a Star Wars bulletin board, and one of the people that came to your bulletin board, your forum, to talk about Star Wars, put up a photo of Yoda, you would get a cease and desist. You would take it down. As the operator of the site, you were protected, right? But that's now been expanded to cover sales on Amazon and other sites that are really more actively participating in the infringement. But yes, it's still one of the first lines of defense for the platforms.
Gotcha. From there is a good jumping off into the world of AI. Do you think AI is going to destroy humanity?
I don't think it's going to destroy humanity. I mean, we've been dealing with or working with AI in a lot of ways for, a long time, right? Photoshop is basically AI, and a lot of the, the digital tools that our filmmakers have, are AI. It's just more powerful and moving faster now, but the output that we've seen, it's funny and it's interesting, but it hasn't quite got to the point where people are, I think, comfortable with the lack of human creativity. Could it get there soon? It could, but right now I think it's not at the point where it's going to destroy the creative industries that some people are concerned about?
I think, people have once again, laymen have a difficulty, or consumers have a difficulty differentiating, their version of AI is some deep fake. That's why they freak out. They're like, this is going to confuse me and make me believe some false propaganda.
So there could be that, right? Because you've seen some of the videos with people that are saying things that obviously they never said, and that could be quite dangerous.
I think that the platforms could very easily police that. I don't know why they don't. I would think they can police so many things, right? They have such, the AI they use, why can't their AI police that AI? But, obviously they love the views, they love the drama, they love the clicks, they love the attention. But that could very easily be dealt with. But, there's so many other cool purposes for it, like if you are a creative, but then you have the true hardcore creatives that hate it, that feel like you have to slave over the thing for it to be valuable. Which, I don't think they realize that, like, E.T. was not Steven Spielberg. It was him and 500 people. Like, whatever album you love, the artist did not design. You might love that artist's logo. You might like. I talk about this all the time. Hip hop, the curation of hip hop. Labels in the 80s, 90s when they were launching hip hop, it was such a diverse creative force behind that. The guy who directed the video generally was not a hip hop fan. He was some pop dude. And the person who took the photo was like a cool person that was on the scene. It wasn't technically the artist friend. It certainly wasn't the artist. The artist didn't design their logo. They generally didn't art direct their album cover. They certainly didn't direct their video. Chances are they didn't produce the music. So that's a million different people that have collaborated on that thing that you love, that you really only focus on. That had to be my favorite artist. I don't want to use any names, but that had to be the guy I love, the lead singer or the rapper. And they fixate on that, and they give all the credit and all the creative everything to that person, not thinking about. It's kind of a really, I don't know if it's not selfish, it's not careless, but it's kind of just a very uneducated view of creativity.
It's a facile way of looking at it. Particularly today where one song may have like 20 writers, producers, performers.
For sure, your favorite song's got 100 writers on it. Right. So like the guy you love and 100 people made that. Right. But you only care about the one thing. But what is the difference with one person now can channel the power of AI to do something similar? I really don't see the difference.
It'll be interesting, and hopefully it develops into a tool. Because even in your Pro Tools or GarageBand, there's components that are AI-esque, right? Yeah. And so these will be more powerful. Hopefully, be more powerful versions of that, and it'll help folks make better work.
Let's be honest. Consumers are consumers. They're going to consume. Period. They're not going to create. Generally.
Well, creators are consumers and consumers are creators oftentimes, but sure.
Yeah, but the average consumer who doesn't create, like they just want to consume. They just want to consume the thing. I'm not sure why they're so obsessed with how it's made. They don't care about the food they eat. Generally, they don't care about the ingredients.
Hopefully, people are caring more about the provenance of this stuff.
Well, Amazon has 1 million robots already working in their factories, but I think Amazon is probably one of the most loved brands in the world, and like no one is stopping buying.
It's always
Amazon.
In the top 10, that's for sure.
No one's stopping buying Amazon because they actually have replaced jobs with robots. But people are generally.
It makes the system more efficient, and they're able to pass on savings because of it, and so people see the upside.
They're irate when they see a rapping baby on Instagram. I find it interesting. But let's talk about music AI and what you can do, what you shouldn't do, how you can protect it, if you can protect it. What do you think?
Well, that's a pretty broad question, but we can start at the end. Can you protect it? If it's a completely machine-generated song, you cannot protect it. The Copyright Office has been pretty clear on that so far. Going back to a case where a monkey took a selfie, the famous monkey selfie case, the court said, look, the Copyright Act's pretty clear. Art can only be copyright protected if a human creates it. So monkeys are out. Also out, robots, all right? Large language models, AI. So if it's completely auto-generated or AI-generated, not protectable. The line starts to get a little more blurry when you look at works that incorporate AI generated material with human created material. You know, if I do 3/5 of the song and then 2/5 of it's done through AI generated music and I combine those, I can arguably have a copyright in what I contributed to it. Now, with all of those elements mixed together, it's going to be difficult for an infringer to say, well, I didn't copy your work, or you can't sue me because 20% of the song's not protectable, right? They'll have taken everything. And arguably, if they just went in and pulled the tracks that were AI generated, copied those alone, then I probably wouldn't be able to bring a claim. But it's going to become, you know, very granular when we're looking at works, because I think that's really the future. I don't think works that are AI generated alone are going to be all that exciting. It's going to be the works that are AI generated with some human involvement, some human creativity, and those two things melded together. And so there have been a couple of cases where the Copyright Office has come out and said, if you have a work like that that has AI and human created elements, we're not going to give you a copyright for the AI generated elements, but we will give you a copyright for the human generated elements. And so we're seeing that kind of move through the process.
So technically, you make an AI song and you don't do anything. You say, make me a song about candles, and it does. Mm-hmm. You can sell it, you can commercially exploit it, you can make money off of it. You just can't protect it with a copyright certificate. You can't register it for copyright. And if someone steals it, you can't do anything about it.
You can't protect it by copyright. Now, there's other ways to protect it, right? I mean, we talked earlier about your idea for a TV show, and I said, well, ideas aren't protectable, right? Because they're free as the air. But you can protect an idea through contracts, right? I can make a deal with you and say, I've got a great idea. I'm a copyright lawyer, so I know artists that ideas are not protected by copyright, but I want you to sign this contract that says, Scott is giving me this idea only if I agree that if I create it, or that if I do something with the idea, I'll create that project with him. You sign that, we then have a contract. You steal my idea, I can sue you for breaching that contract. Maybe not a copyright claim, because no copyright, but there's a contract claim. Could you theoretically do something like that with AI works? In theory, you could.
But that kind of protects you on a one-off basis.
That only protects you with your contracting party.
Right.
Yeah, if you make a deal with a big shoe brand and they use your music and then some other shoe brand likes it, they can copy it, use it, and there's no...
I wonder if there's going to be a movement of, you know, just, I don't know how people can tell what's made with AI or not, but if they did, let's say there's some really awesome AI Instagram page that rolls out all this incredible AI music, and the big labels are like, great, we can take this and use it and you can't do anything about it.
Yeah, that would be a problem.
Right? But if you wrote the lyrics and AI generated the music and you filed a copyright and you said, I wrote the lyrics, musical composition AI generated, and you were exploiting it around, whatever it's on you're selling it, doing whatever you do with it, and some big songwriter, pop star, takes the music, but not the lyrics.
Totally fine. Yeah, if they take the musical bed that was AI generated, they'd leave your lyrics behind that you have a copyright in, then
you're not, you got no claim.
No
But
claim.
Don't you, when you fuse together, no, nothing. In the real world, in the real world, yes, you become a finished composition, but AI would not be considered a collaboration.
Right, there's not enough there for that to be protectable.
Right. Okay, very cool. So artists that are using AI, what do you recommend?
That they use it ethically. You know, we always say there are ethical AI companies where you're using generated music that's being generated from a pool of works that have been licensed or that the authors have consented to the use in that pool. You know, that's, I think, the best way to do it, because there are a number of cases going through the courts right now addressing whether or not the output from a lot of the AI programs violates the copyrights when the LLM's intake is all stuff that nobody agreed could be used for the derivatives that are AI generated. And so I would absolutely do that. And then I would try to use as much human creativity as possible. You know, think of it more as a tool that will augment and make your work better or expedite your creative process, as opposed to relying on it for much of the creativity that will ensure that your copyright is stronger, or that if people are infringing, they're actually taking what you contributed as opposed to the machine. And then I would look at contractual options for protecting stuff that's otherwise not protectable by copyright.
Do you see a future where you're representing AI avatar musicians?
Well, there was a recent, Velvet Sunset, was that the band? There's a recent band that was it became very popular, and then folks realized, oh wait, this is just an avatar, it's not a real band. And that showed that, you know, these avatars can generate money, right? They can generate revenue. But all of those, the problem with that model is all of those songs, anyone can then take them and upload them themselves, right? And so I don't think it's a business model that's sustainable. You know, you can have that sort of initial pop like they did, and everybody thought it was, you know, interesting.
Was that pure AI, or did someone write a portion of that?
I feel like it was primarily AI, but don't quote me on that.
Yeah.
There could have been some human involvement. But I don't see that as being the case, because they're never going to have, the avatars will never have, at least under our current laws, copyrights to enforce.
So they can make money however they can, but they can also be ripped off equally. So let's say you know, they have these AI influencer girls that have Instagram pages with 1 million followers.
Lots of followers, sure.
So if I want to go, not me, but if Kevin, a cameraman, wants to go and make an identical page and take all of those photos and put them on that page, they can't do anything about it.
Well, that raises two interesting issues. Right? One is that the photograph that's taken, it depends how that photograph is generated, right? Because I could, in theory, even have an AI avatar on my screen, and I take the photograph, I may have a copyright in that photograph. So that's an interesting issue. But if you're just taking the audiovisual file that is that influencer, then you're probably going to escape the copyright.
I'm thinking some of these things I'm referring to, I believe are purely created, you know, like it's
100% generated by the machine.
Yeah.
Yeah, then you can take that and do whatever you want with it. And I think that's in fact happened quite a bit. But there's another issue when you're talking about avatars that we haven't talked about, but I think would be of interest to folks, and that's the third type of IP that we see the most, and that's publicity rights, your name, image, and likeness. It'll be interesting to see if those folks can claim name, image, and likeness, because that's not constrained by that same human element that we see in the Copyright Act.
Right, and that's an interesting nuance no one really understands. So and this is kind of complicated to even say, so if famous pop star is photographed by paparazzi, and paparazzi does not give famous pop star rights to license their image, and famous pop star posts paparazzi's photo on famous pop star's Instagram page, paparazzi can completely sue famous pop star. Happens all the time, right?
There's three pieces of intellectual property that could potentially be in a photograph, right? The photographer that takes the photograph, who fixes it in a tangible medium by hitting the button, they have the copyright in their photograph, right? The individual creating this video, hitting the button, he's gonna have a copyright.
Pause. Can you give me a quick work for hire, somebody? Kevin's got to sign a work for hire.
Right. But if the photograph has a subject in it, an individual, that person has a right of publicity. And so the photographer will be able to most likely use the photograph of the subject in editorial works, books and prints, things like that. But to use it on merchandise, they will often need the subject to sign off, because what the right publicity says is that, and again, the copyright is federal, federal court, one statute that applies to all of the states. The right publicity is individual. So each state is going to have a different law, or some don't even have a law. They have common law that they use to enforce the right publicity. But most of the statutes are going to say something like it has to be used for merchandise purposes or advertising in a commercial way. So not a First Amendment protected artistic way, but a commercial way. And so, yeah, if you want to sell a T-shirt with a photograph of a famous musician, you have to have the copyright from the photographer, and you have to have the right publicity from the musician. And maybe the musician's wearing a shirt with a Nike swoosh on it. You may need to look into that trademark as well. So it can get very complicated.
I'm glad you went there. I was just keeping it the first step, which was like, pop star can get sued. I don't think the average person realizes. They would think, oh, that's a picture of my favorite pop star. How dare the photographer be able to sue them for just using, they just want to put up the picture of themselves on their page. What's wrong with that?
Right. And so we always say, well, look, there's two sets of IP, or you should know that as a pop star, as an artist, and reach out to the person, say, hey, is it cool if I, use the photograph?
Yeah.
Make a deal.
If the entertainment industry would just reach out to the person, there'd be such less problems.
Make it easy.
Right?
Everyone should just be talking to each other more.
They never reach out to the person. Too many egos involved. But you see that often, right? Where a pop star who should know better has to put up that picture.
Yeah. And you have to think, like, they don't have a copy of it, right? So that means, like, they've gone to the photographer's website and made a copy of it and saved it and uploaded it. So it's,
totally willful.
There's a lot of willfulness there. Yeah. And, there's questions of damages and other things. But from a copyright perspective, if you want to use something created by someone else, go to them and get a license. Talk to them about it.
And what about me as a Milk Crate logo? What if some famous artists wears my bucket hat with my logo on the front and posts it on their page where I should be thrilled about it? I can sue them if I want to.
Well, I don't know. That's a trademark, right? Well, if your logo is copyrighted, then you have an argument that, they're using your copyright without your permission.
But there's also a fair use side of this. Does that play at all?
It's possible. It'll depend on, they look at a number of factors, the most important of which is the market impact. Is this person wearing it on their account going to hurt your market for licensing or monetization? Arguably, it could help you, right? I mean, there's an entrenched history of brands paying people to wear their stuff, and so you might have a tough argument there. But again, everyone should be in touch, communicating, licensing.
And I love that you went right to photographs on T-shirts, because it's been such a big part of the Milk Crate brand and all the other little brands that I know, and so much confusion as to, first of all, just straight ripping off to, I got the photographer's permission, I'm fine, to a state coming after them to, this is all pre, major licensing companies getting, now you got $1 million, everything's licensed. So this is pre anyone caring about that IP. So interestingly enough, the cottage industry really did pave the way for what now is
huge current
which now is just like Target, Walmart, right? Getting your favorite Boys in the Hood T-shirt at Walmart for $15, or what's it called, Fiverr or Five? The Five store where you apparently, I can't remember.
Everything's $5.
Yeah, where you can buy the Biggie Smalls with the crown for $15. And here's an interesting story there. Statute of limitations is well expired on this, but. I hope, right? 3 years, regardless, right?
It should be 3 years.
Okay, so back pre-internet, early internet, rap pages, classic photo of Biggie Smalls with the crown, and this is a Milk Crate, Milk Crate. I don't know. This is certifiably for sure. This story. So Biggie Smalls with the crown, the image.
Sure,
now,
know it well.
There was a point where no one knew it, and it was on the Rap Pages cover, and Rap Pages went out of business. Pre-internet. It was gone, right? It had left culture. Mm-hmm. Me knowing it, I actually, oddly enough, knew the girl who styled it.
Okay.
Who put the crown on his head, oddly enough. And it was an early thing where Biggie was kind of just brand new. And it was like, it's kind of cool, but hey, whatever. Rap Pages even was kind of like, it's not the source. So it wasn't like this hugely known cultural moment, incredible photo, but just didn't get the reach that it needed at that point. So it had vanished. So I'm like, would make a great T-shirt. So I went on eBay. It was on, you could still, eBay existed, but there wasn't where you could put like Biggie in the crown and it was on someone's blog. It just wasn't out there. Shit wasn't out there like that. Was able to buy the Rap Pages, or I might have had the Rap Pages, I don't know. Airbrushed it, cut it out, made this incredible photo of Biggie in the crown. Took an old mugshot thing, and so I altered it slightly, probably didn't count, but added Frank White, King of New York. So he used King of New York. So the crown, we put King of New York. It was in a Milk Crate tee. We were selling it everywhere. It was hotcakes. It was this beautiful multicolored photo print, like merch, like today's merch, like today's music merch. Ultimately, that's what Milk Crate was. It was the formula of great record. You were around them. Great record label promo shirts that only the cool guys got. Right, like if you had the De La Soul whatever shirt that they made, like 100 of. You were either a VIP in A&R, or just premier college radio DJ, So I wanted to continue the spirit of that once that kind of faded away. But this Biggie tee was a huge thing. So Jay-Z ends up wearing it in his fade to black, buys it from a store, stylist gets it, wears it in the fade to black, his, you know, retirement movie. And it had gotten to major, this was a major seller. So at some point, Baron Claiborne, shout out Baron, comes along irate, and we worked out a deal. But still, like, Baron got paid, and I have the document, the agreement that we did to continue selling it. But obviously, I didn't know I needed Biggie's estate at the time. Mm-hmm. And then a friend connects me with the dude who was, can't remember, I think it was Wayne Burroughs or something, who was the Biggie's
Barrow, I think.
Barrow, who was running the Biggie estate at the time. And he picked me up one day on St. Mark's Place in his Navigator, and we went for a ride, and he's just like, I like what you did, but just stop. But you gotta realize, like, the Brooklyn Mint brand, I mean, it was Brooklyn Mint was a very, very early streetwear brand. I mean, people may say it's not streetwear, but they had merch, like a Biggie brand called Brooklyn Mint.
I know it well.
Super early. At the same time, Fat Joe had Fat Joe 560. At the same time, Fuji's had some brand. I mean, there was a spot on 30-something Street that I went up one day, and this guy printed all of that shit for some reason. It's like when you would still have a screen printer in Manhattan.
Right.
Manhattan, like they could be afforded today. And he printed all of that it was like a bunch of those guys. But long story short, that my usage, like we talk about the cottage industry and what it does, and yeah, it's an infringement, but is there a greater service provided as kind of an incubator, or I don't know what you would call that, but they went on to be like that Biggie and the Crown. They certainly weren't using that for Brooklyn Mint.
Right, you helped make the market for it.
They didn't see the value for that. Mm-hmm. Now, then it became the Brooklyn Mint logo, right? Okay, and after Jay-Z wore it, right? And then it became, I mean, I can't go anywhere with seeing 5 variations of Biggie with the Crown, right? It's either the baby with the crown, Biggie with the crown, an Andy Warhol version of Biggie with the Crown, camouflage version of Biggie with the Crown, everything Biggie with the Crown. Like, it's everywhere. It's baby versions, adult version, 5XL version. So me kind of resurrecting that did a service. Would you agree? Is there an argument to be made for that?
You help to market, and you create a market for it, right? Create a demand for it.
But could I, in a litigation, could I say, hey guys, you weren't using this. How much are you making off of this because of my efforts that I technically wasn't compensated for in any which way, other than my usages? You've made $5 million. I made 500. What are you mad at me for?
Right.
Is that an argument?
I mean, probably you'd still lose, but being a good business person or having a good eye, not protected by copyright or trademark or right of publicity or any of those things. Yeah, that's what when I say there's different pieces or types of IP, intellectual property, in a photograph of a subject, that's what I mean. The copyright holder can come after you for the copyright claim, the subject can come after you for the publicity claim, and you'd potentially be on the hook for 2 lawsuits. And
if, let's say there's a famous iconic photo that has a milk crate banner in the background. That's fair use? That's public domain?
It's a good question. It could either be fair use, it could be what we call de minimis use, meaning it's not a big part of the art, so it's not infringement, or there could be a claim. There was at least one case I can think of where there was some street art in the back of a television show, and it wasn't foregrounded, it was quite small, and you could barely see it. It was on screen for like half a second. And the courts will say, well, something like that, it's probably de minimis use because it's just so fast. But if it's on screen for a more substantial period of time, and as the viewer, again, going back to the viewer, the role of the jury and looking at this stuff and asking whether or not it's valuable, then they're using it for set dressing, then maybe you would have a claim.
Well, I don't understand why Nike has to get blurred out, but Milk Crate Athletics trademark does.
In theory, it should operate the same.
It should operate the same. So street art in the background. Recently, I've heard that Subway Legends, their work ends up all over the place. But I've heard recently that a graffiti artist potentially can sue if someone uses their work that's technically vandalism on the side of a building, on a T-shirt or in a film or even an Instagram post.
We have tons of cases, or we've handled tons of cases for street artists whose art has been either used on merch or has been used in the background of a film or a commercial. It's a very common type of case because these brands want to get the credibility of having their car parked in front of a really beautiful piece of street art, and they don't, for whatever reason, reach out to the artist and get a clearance. And so, absolutely, even though whether or not it's vandalism doesn't really matter, it's still art once you fix it in a tangible medium, and putting the art on the wall fixes it. So they have claims. Now the question of folks that are taking photographs of art, it becomes a little bit more difficult because of the certain laws that allow folks to do artistic expression like that.
But so if they took a photo, it might be off the hook. But if it's used in
well, a photo in a book of that's a collection of street art is going to have a much better argument that it's not a violation of the artist's rights than a brand who's used the street art in the back of one of their commercials.
I saw a class action. I don't know if I don't know how real it was. It popped up. I glanced at it, where an attorney filed a class action on behalf of a bunch of individuals who all bought this cosmetic product or whatever it was. Maybe it was a shirt. I don't know. It doesn't really matter, right? They bought a product that they believed was going to do something. Let's say it was cosmetic. They thought it was going to help them. And whether it helped them or not, it didn't matter. They bought it because of this influencer said it did these things, and they said they used it for these things. And that piece of content was not clearly identified as an advertorial or a paid ad or an ad in any way, or a hashtag ad or whatever. There's apparently a whole criteria. Is any of this on your radar?
Yeah, there's absolutely these truth in advertising rules and unlawful advertising or deceptive advertising rules. And if you're going to put something online, this goes back to what I was saying before, how the wild west nature of the social media platforms, TikTok and Instagram in particular. These are advertising platforms. It's not just a sort of a hobbyist thing. These are brands paying people to sell products. And when you have advertising, just like it was on television or a billboard, you see in a commercial all the disclaimers, all these things that are making clear that these folks are in compliance or that they're in compliance with those television advertising. The same exact thing for social media. And so if somebody's telling you that, I love this face cream, and they're not telling you I'm being paid to tell you I love this face cream, that's deceptive.
And there's huge fines, apparently.
There's fines, there's penalties, there's all sorts of trouble that you can get into. And what's interesting is it's not just the brand, it's the influencer themselves.
And the agency.
And everyone that's involved in deceiving the public.
But I feel like, with supplements,
supplements, crypto people as well.
There's brands making $20 million a month with a million influencers, TikTok shop people, who are going viral, who are creative kids, who know how to make a piece of content. And I've spoken to someone, I said, is this an FTC violation? And they're like, no, because when we link a TikTok shop product, it clearly shows in the bottom that this is a something or other. And I'm like, I saw FTC had like a 5-tier criteria where it had to you have to state, they want you to state in the video something. They want it to be first hashtag, and it has to be on screen some sort of this is a paid thing, which obviously defeats the full purpose of believing that this is an influencer.
The authentic, you're right.
Yes.
Yeah. The rules in general are trying to make sure that it's conspicuous, right? It's not, we make rules saying you have to say it, then you do it in tiny font that no one's ever going to read. Like that's not, in compliance.
It's almost a boiler room. This is a huge industry that's operating underneath the consciousness of, I don't know how far the FTC can enforce it. I don't know if individual law firms are, you would be on the others. You wouldn't be really, that's not your thing.
It would be interesting where we would come in on that, because we're always on the creator side. Yeah. But our creators, of course, would never do something like that, so we'd never have to defend a case like that.
Yeah. But I guess like that, that's the future of everything, and it's kind of, that's not even the future. It's the current form of
advertising dollars of.
It's all there. It's all gone there. And I guess if you, I guess you're you're kind of operating, unless you do it specifically that way, which probably would deem your content useless, I would think.
It would be more like a commercial and wouldn't have that authenticity that people like.
Which people are believing, you're falsely believing in a thing, right? So that's That's a very confusing area right now. I'm sorry, are you seeing cases come across?
Yeah, I mean, there's people that are upset because they've been misled. You know, there's the government issues that folks should be compliant.
Do you know any like actual cases that you can comment on that you found interesting that were, did they get dismissed or are they proceeding along?
Nothing in particular I can think of off the top of my head. Gotcha. In that area.
Okay, so for all my old school rap fanatic friends and artists and producers and rappers and everybody, like I know everybody's talking about what is it called?
The termination right.
Correct.
Mm-hmm.
Yes, termination right. And there's a ton of confusion around termination right. Is that specifically for masters or publishing too?
This is for any copyrighted work. So this is one of the parts of the Copyright Act that were written into it to protect artists that artists just don't know about, or they don't know about to the extent that they should. But what generally happened was Congress realized that artists, when they make their first deal, they don't always make the best deal. In fact, they often make a very bad deal. And so they wrote into the Copyright Act a right for the artist 35 years after that first deal, all right? So 35 years have gone by. The first person that made the deal with them has had 35 years to make money off of this work. The artist at that point can send to them a termination notice, and it's a bit complicated, it has to comply with these certain provisions, but they send the notice, and then 2 years from that notice, they get the rights back. And at that point, they can make a new deal, they can exploit them on their own, but in essence, they're able to undo that bad deal that they did 35 years ago and get the rights back. And so anybody that was creating art about 35 years ago, you should really be talking to a lawyer, you can call me, and figuring out whether or not you can terminate your rights, or your rights transfer and get it back. We just did a trial at the end of last year for 2 Live Crew, you know, the seminal rap group, and they had made a deal that was not a great deal, and we were able to get their rights back for them, you know, through the court system, and that's available to anyone. You know, anyone that entered into a contract 35 years ago, you can talk to a lawyer about potentially getting those rights back.
What was the date of their first album, you know, offhand?
The details of it, you know, we don't want to talk about, I really can't talk about too much, but those were all...
They were like early 80s, like they had records coming out late 80s,
early 90s.
Yeah, so right now the block of time that an artist, if you had commercial releases within, what is it, where are we at? What's the window?
Around 1990.
1990.
Yeah. You do have to give 2 years notice, and you have to send it in the window between 35 and 40 years. But you can send it ahead of time as well. So you can send it up to, I believe, 10 years before the termination.
Can they contest it?
Oftentimes they do. They often will contest it. And there are a number of defenses that they've been using in court, some of which have been successful, others, you know, haven't been. For example, work for hire. If it's a work for hire, you can't terminate.
Wow.
That's a problem. But you know, otherwise, you should be able to talk to a lawyer and see whether or not you can bring it.
Does it matter if you sign the deal personally or as a company, incorporation?
That sometimes matters, yeah, because the artist is the one that can terminate. And so there's this question, well, can a company terminate? Is the company the artist? Will work for hires? You know, you can't do it. So there's this a lot of gray area. This was something that was only put into the '76 Copyright Act, and because 35 years had to go by, it wasn't until the 2000s where people started bringing claims. So it's still being developed. But it's just a powerful tool that not enough people know about.
But it applies to publishing companies as well, obviously.
It applies to every deal.
Yeah,
publishing deal, a record label deal, any deal.
Any deal. But when usually you sign, you know, the record deal for a sound recording, that's typically a work for hire language in there. Typically, when I've seen them, they want to own that master, right? And it usually has work for hire language in there, referring to the 1976 thing, and does that deem a work for hire?
Well, that's an interesting one. Sometimes it can. You know, sometimes you see that language and it can.
Right there. We've exposed a million gray areas here, I think, in every topic that we've touched on, that the average person would just think, what me worry.
Right,
remember that?
right, yeah, what me worry, Alfred E. Neuman. Yeah, do not Alfred E. Neuman. You worry about everything. You know, call the lawyer, let the lawyer, you know, help you out. Not every lawyer costs $1 million and you have to, you know, pay 10 grand just for the, you know, consultation.
Yeah. There are good guys like this guy and his firm that really are advocates for artists and creatives and do care and will fight for you and will help you. So don't think it's a scary, and they are very artist friendly. So don't think it's a scary, you know, experience. It's actually a trusted ally that you're going to need and want to need, and you'll learn a lot. So make the call, do your homework, do your due diligence, set yourself up properly. Reach out to Doniger Burroughs, Cali, New York, East Coast, West Coast, worldwide, and get protected and get successful. Certifiably Milk Crate. Thank you, my man.
Thank you. It was
It's
a
been
pleasure.